All right, folks, we now need to turn to the remaining counts in Mr. Bassett's case, employing a firearm during a dangerous felony with a prior conviction. I want to address one thing to begin with. The state's indictment lists two predicate prior felonies to which they believe that should is employing firearms. The court has previously held that under that statute, 39-17-13-24, that not all felonies count. I was recently affirmed on that in the state of Joshua Bowman, and so I am going to strike the vandalism charge from the indictment. The felony drug case is considered a dangerous felony under the statute. So, General, at this point, you need to redact the presentation presented. Don't read the vandalism. We'll bring the jury back in. We will publish those remaining counts, enter the plea, and then it's just a mini trial. Each side can make an opening statement if you'd like. Present whatever proof you have. I don't know if you can call Ms. Ogle or who for judgment.
It's an out of county prior. I've got a certified copy, and I do have Ms. Mooneyham here, TDOC. You can testify about the same number.
Okay. All right. So, are you ready for that, General?
Mm-hmm.
Ready, Mr. Jones?
I am.
All right. Receive the statement of acknowledgement?
Yes.
Defense acknowledgement?
Somewhere there.
Well, folks, there are some additional counts that regard Mr. Bassett only. We have bifurcated those for you because there's going to be some additional proof that was inadmissible in our original trial in this case. And so it's going to be kind of like a mini trial. Basically, each side gets to make an opening statement if they want to. They present whatever proof they want to, closing arguments, and then I have to deliberate on these last few counts. So we're going to start at the beginning. General, if you please publish the additional counts regarding Mr. Bassett.
Sixth count. And the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett heretofore to wit on or about the 17th day of December 2015 in the state and county aforesaid did unlawfully and knowingly employ a firearm during the attempt to commit a dangerous felony, to wit, attempt to commit first-degree murder of Zaevion Dobson, as defined in TCA 39-12-101 and 39-13-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows. That in case number 73594 on the 20th day of April 2015 in the criminal court for Rutherford County, Tennessee, Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance in violation of TCA 39-17-13-24 and against the peace and dignity of the state of Tennessee. Ninth count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett heretofore to wit on or about the 17th day of December 2015 in the state and county aforesaid did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Faith Gordon, as defined in TCA 39-12-101 and 39-13-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows. That in case number 73594 on the 20th day of April 2015 in the criminal court for Rutherford County, Tennessee, the said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance in violation of TCA 39-17-13-24 and against the peace and dignity of the state of Tennessee. 12th count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett heretofore to wit on or about the 17th day of December 2015 in the state and county aforesaid did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Kiera Rooker, as defined in TCA 39-12-101 and 39-13-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows. That in case number 73594 on the 20th day of April 2015 in the criminal court for Rutherford County, Tennessee, the said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance in violation of TCA 39, 17, 13, 24, and against the peace and dignity of the state of Tennessee. 15th count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett, heretofore, to wit, on or about the 17th day of December, 2015, in the state and county aforesaid, did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Xavier Malone, as defined in TCA 3912-101 and 3913-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows: that in case number 73594 on the 20th day of April 2015, in the criminal court for Rutherford County, Tennessee, the said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell of a Schedule 6 controlled substance in violation of TCA 39, 17, 13, 24, and against the peace and dignity of the state of Tennessee. 18th count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett, heretofore, to wit, on or about the 17th day of December, 2015, in the state and county aforesaid, did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Louis McNair, as defined in TCA 3912-101 and 3913-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows: that in case number 73594 on the 20th day of April 2015, in the criminal court for Rutherford County, Tennessee, the said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell of a Schedule 6 controlled substance in violation of TCA 39, 17, 13, 24, and against the peace and dignity of the state of Tennessee. 21st count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett, heretofore, to wit, on or about the 17th day of December, 2015, in the state and county aforesaid, did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Latasha Colbert, as defined in TCA 3912-101 and 3913-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows: that in case number 73594 on the 20th day of April 2015, in the criminal court for Rutherford County, Tennessee, the said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance in violation of TCA 39, 17, 13, 24, and against the peace and dignity of the state of Tennessee. 24th count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett, heretofore, to wit, on or about the 17th day of December, 2015, in the state and county aforesaid, did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Jayshawn Colbert, as defined in TCA 3912-101 and 3913-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows: that in case number 73594 on the 20th day of April 2015, in the criminal court for Rutherford County, Tennessee, the said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell of a Schedule 6 controlled substance in violation of TCA 39, 17, 13, 24, and against the peace and dignity of the state of Tennessee. 27th count, and the grand jurors aforesaid upon their oaths aforesaid do further present that Christopher Bassett, heretofore, to wit, on or about the 17th day of December, 2015, in the state and county aforesaid, did unlawfully and knowingly employ a firearm during the commission of a dangerous felony, to wit, attempt to commit first-degree murder of Jayla Bowers, as defined in TCA 3912-101 and 3913-202, and that said Christopher Bassett has heretofore been convicted of a felony as follows: that in case number 73594 on the 20th day of April 2015, in the criminal court for Rutherford County, Tennessee, said Christopher Bassett was in violation and convicted of the offense of manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance in violation of TCA 39, 17, 13, 24, and against the peace and dignity of the state of Tennessee, signed by Sharm P. Allen, District Attorney General.
Thank you, General Fitzgerald. Mr. Gaddis, how does Mr. Bassett plead to the main count?
Entered into his plea of not guilty, Your Honor.
Thank you, sir. All right, folks, so the next part, the parties are given an opportunity to make an opening statement if they wish to do so. Once again, the state has the burden. They get to go first. Gentlemen, would you like to make an opening statement?
Yes, Your Honor.
Go ahead.
Ladies and gentlemen, this second part, basically, we're going to introduce proof that Mr. Bassett, at the time that he possessed that firearm and committed the attempted first-degree murder conviction that you found him guilty of, that he had this prior felony conviction. The proof will be that on April 20th, 2015, he was convicted in Rutherford County in docket number 73594, manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance. That is a dangerous felony.
Thank you, General. Mr. Judge, would you like to make an opening statement?
No statement desired, Your Honor.
Thank you, sir. All right, folks, it is now time for the state to present its proof. General, will you please present your proof?
Your Honor, we would first like to make, as an exhibit to these proceedings, a certified copy of docket number 73594, count 1.
Stipulation part of this stipulation already entered into.
Any objection?
No objection, Your Honor.
This will be exhibit 627.
And we would also like to make the previous exhibits of this trial.
Yeah, what's easier for you? Let me say 627, and then we'll know that it applies to pass it on. It'll be 627.
And Your Honor, we would ask that the previous exhibits to the trial be made a part of this proceeding as well, because we're going to rely upon the
The
stipulation.
previous exhibits as well as the previous instructions will be tendered to the jury.
What was that exhibit, Your Honor?
627.
Thank you, Your Honor.
Call Lisa Mooneyham.
Mr. Mooneyham, would you please come forward and take the witness stand? Please raise your right hand. You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat, Ms. Mooneyham.
Please give us your name.
Lisa Mooneyham,
Can you spell your last name, please?
Mooney, Cheltenham,
Where are you employed?
Tennessee Department of Corrections.
And what do you do with the Tennessee Department of Corrections?
I'm state enhanced officer.
As a state enhanced officer, what is enhanced? What is that? The jury, they probably don't know.
We supervise high-risk probation.
Now, the probation office, do you have a database that contains information about all of the offenders?
We do.
And how are you able to maintain that database on each offender?
Well, in each county in the state, if they're convicted of a felony, it's in the computer system, the TOMAS system, which is the Tennessee Offender Management Information System that we use.
And as each offender, do they have a specific number?
The TOMAS number, yes.
And are you familiar with Mr. Christopher D. Bassett?
Yes.
And you'd recognize him here today?
Yes.
Mr. Bassett, were you able to access your records to determine whether or not he had a prior conviction out of Rutherford County?
I did. Yes.
And tell us what you were able to determine.
I have looked up in our TOMAS system under the code LSTQ, which indicates he has a conviction in Rutherford County for Schedule 6 drugs. It was a 2-year sentence on 4/20/2015.
And what is his date of birth?
His date of birth is 7/29/95.
Did you give us the docket number?
Docket number is 73594.
And did you point him, did you ID him for the record? What is he wearing today?
He's wearing a suit, it's not a blue suit, navy suit.
The African-American gentleman?
Yes.
Record could reflect the witness identified the offender.
Very well.
Last witness.
Cross-examination.
No questions, Your Honor.
Thank you, Mr. Mooneyham. You may step down. Free to go. Further proof from the state?
And a statement will rest.
Any proof from the defense?
No, Your Honor.
Argument, John?
Ladies and gentlemen, we would ask you to find that proof to be credible, and find that Mr. Bassett, at the time he committed these crimes, did have a prior dangerous felony, that being possession with intent to sell marijuana.
Mr. Jones, would you like to make a closing argument?
Ladies and gentlemen, difficult thing to do when you have just had a verdict returned relative to what has been a very difficult case for both yourselves and everyone involved relative to the same. Obviously, we respect the jury process and we respect your considered deliberations relative to the counts that have been placed before you, but Mr. Bassett continues to emphatically rest upon his innocence. That being said, we would ask that you return a verdict of not guilty relative to these additional counts. Thank you.
Thank you, Mr. Jones. General, everybody.
Mr. President, and again, we just remind you that during the case in chief, the defendant stipulated that he had a prior drug conviction, felony drug conviction, and that is a copy of, certified copy of that felony drug conviction that we introduced.
Thank you, Chairman. All right, I'm going to instruct you one last time. The instructions I'm going to give you include the previous instructions. Will you please direct your attention to the board, follow along as I read these instructions. Members of the jury, you have now determined that the defendant Christopher Bassett is guilty of employment of a firearm during the commission of a dangerous offense as charged in counts 5, 8, 11, 14, 17, 20, 23, and 26. You must now go further and make additional findings. It will now be your duty to determine whether or not the defendant has a prior conviction for manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance. Any prior record of a conviction of the defendant is evidence which you may consider. A judgment of conviction of any person under the same name as that of the defendant may create an inference that the identity of such person is the same as the defendant. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. Prior conviction means the defendant has served and was released or discharged from, or is serving a separate period of incarceration or supervision for the commission of manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance at the time of the offense for which the jury has found the defendant guilty in counts 5, 8, 11, 14, 17, 20, 23, and 26 of this presentment. Separate period of incarceration or supervision includes a sentence on probation, parole, or community correction or supervision, or of incarceration, or assigned to a program whereby the person enjoys the privilege of supervised release into the community, including but not limited to work release, education release, restitution release, or medical furlough, or on escape status from any correctional institution when incarcerated. If you find beyond a reasonable doubt that the defendant has a prior conviction for manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance, your verdict will be, we, the jury, find the defendant has a prior conviction for manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance. If, however, you do not find beyond a reasonable doubt that the defendant has a prior conviction for manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance, your verdict will be, we, the jury, find the defendant not guilty of having a prior conviction for manufacture, delivery, sale, and possession with intent to sell a Schedule 6 controlled substance. You will take with you the court's previous written instructions. You should follow such previous instructions as the law of consideration of evidence, deliberations, reasonable doubt, witnesses, and any other relevant matters. You may now retire to consider your verdict. So at the end of the book, hold on a second. You'll find the verdict form. There's one for each count. You'll see the difference is listed at the top of the verdict form, even though the findings, the allegations are the same in each count. The sixth count regards the employment of a firearm during the commission of dangerous felony, the attempted first-degree murder of Zaevion Dobson. And so you'll circle either A, we the jury find that the defendant has a prior conviction, or B, we the jury find that the defendant is not guilty of having a prior conviction for a drug conviction. And then the foreperson will need to sign and date it. Then the other counts look very similar, except we have the different alleged victims. The ninth count is during the employment regarding Faith Gordon. The 12th count, the employment regarding Kiara Rocker. And on down the road, Xavier Malone's 15th, and so they're all the same. All right, so I'm going to send these instructions. They're in this book, but I'm also going to send the original instructions with you. The verdict forms for the last remaining counts are in this booklet. At this time, you can take notebooks, return to the office, and resume deliberations. Maybe you may be seated. Any additional statements?
We'd ask court to go ahead and send us on the murder count.
Big impact and all that. Are you prepared for that, Mr. Jones?
No, Your Honor.
Mr. Morton, General, normally I would do that, and if Mr. Bassett was the only defendant, I would grant that request, but I really want to do the victim impact statements one time.
Okay.
Obviously, the sentence for the first-degree murder of Zaevion Dobson will be a life sentence. However, she has a right to make a victim impact statement. As I said, I don't want to put her through that multiple times. Ms. Dobson, I want to ask if you would wait until February 1st before we enter the sentencing on Mr. Bassett regarding that one count, all right? The court's going to stand in recess until we have a verdict. Anything else? Sure, hold on a second.
Just want to make sure that
Hey, also, I need Mr. Dobson back. Folks, the Attorney Generals are informing me that I do have to go ahead and enter the judgment now. We're still going to wait to make an impact till later. Mr. Dobson, I apologize for that. The attorneys informed me and reminded me really that the court is required to go ahead and enter the finding in the third count. Now, you're giving an opportunity to make an allocution and you can make a statement. However, the jury's still out pending certain other cases. So you don't have to say anything if you don't want to at this time. You'll be given an opportunity if you wish to address the court at a sentencing hearing on February 1st. But regarding the sentencing in count 3 of the first-degree murder of Zaevion Dobson, do you wish to say anything at this time? All right, very good. All right. Christopher Bassett, case number 110855, after being tried by a jury of peers and found guilty of the first-degree murder of Zaevion Dobson, the court now sentences you to serve life in prison in the State of Tennessee Department of Corrections. At this time, we're going to recess until we have a further fight.